So, ladies and gentlemen, these guys have a really hard job to do, and I'm eager to hear how they handle it. Go for it, guys.
Well, thank you, Joe. I was going to do some brief introductions, but Joe's done that, so that's great. I'm flattered to be here. I should mention that any of my comments are not necessarily sanctioned by either Steve or Joe, and they did threaten, if I said something really bothersome, that they had asked tough questions. Regulation clearly is a difference maker for an economy and a society. It's one that we all live with, and so one of the questions is how, in fact, in different industries and across the U.S., can we make it as effective as possible? I'm going to speak for just a minute on the segment that I knew for 40 years, financial institutions. I'll only touch on a couple of points, and if you'd like to hear more or want to send a really nasty refutation of all my other thinking, you have to read the book that CED is coming out with in the first quarter. So that, in terms of the financial institutions, let me start with the fact that the intent after 2008 was to make us all safer and make the economy better. One of the challenges is that there were very well-intentioned policies and principles put forth, but in many cases the execution may very well have given us a riskier environment and possibly riskier institutions. I know that's counterintuitive with the massive amount of capital that you keep hearing about, but I will talk about the liquidity issue, which our colleagues before us talked about. One of the things that's happened with the new legislation is that asset classes today are being traded at much smaller volumes. And as with a tsunami, when you have a big wave come in, you have much more volatility. And we're going to see it against a wide category of assets, not just US Treasuries, not just foreign exchange, not just funds, but a whole series. And that's important not only to the corporate and institutions, but to the individuals who may think they have some liquid assets, and when they go to try to change them, instead of getting 100 cents on the dollar, because of the very thin trading, they get 60 cents on the dollar. You may also see that there were something called living wills and stress tests, and those have been something that people have been very proud of. I think they're great ideas. In fact, what worries me a little bit is there's tremendous pressure to do away with living wills and stress tests for smaller institutions. The challenge is economic materiality. I don't know if any of you have any idea how big, for example, the living wills are that the major institutions are producing. They're in excess, in most cases, of 100,000 pages. I don't know if any of you have ever read a book of 10,000 pages, let alone one of 1,000 pages. War and Peace was mine. But when you get to 100,000 pages, no director, no member of management can begin to read it. But worse than that, you've done two negative things. A, you've given a false sense of security because you have this massive volume, but nobody will know what the key Exocet missiles that sink the ship are in those 100,000 pages. The other challenge is you've taken tremendous amount of resources, literally in the hundreds of millions of dollars, and you've diverted them from other activity. And if any of you track where financial institutions have been the last few years, they've been reporting lower operating expenses. And so for any of you that have run businesses, if you have added burdens of expenses, but you're reporting lower overall expenses, that's coming out of somewhere. And that somewhere are the controls and compliance areas you're not looking at. So I am suggesting you've got more volatility in the economy, and you also have more risk in the economy. And at the same time, one of the things that happened with the CSFB, very well intentioned, the consumers need protection, they need fairness, they need suitability. But by creating yet another organization, you have the OCC, the Fed, FIRA, FDIC, SEC, NASD, you just keep going, plus 50 state banks, 50 state insurance, 50 state brokerage services. So you've actually added complexity to the marketplace, and instead of having clarity and continuity and focus, There are some great regulators that have got tremendous policy support out, and they're getting resources. You've got the MAS in Singapore as an example that is paying their folks at market levels. We have not been paying our regulators at market levels, and therefore there's been a problem of being able to hold on to them and keep continuity. So those are a couple of quick comments on the financial institutions, some great ideas, but the execution and the focus on materiality has to be changed, and there is the ability to do it. I will say one more thing, which is I don't think any of the legislation we're seeing for the major institutions is going to go through, and in fact, I think over the next 3 years, my expectation is you'll see more regulation added to what's already there rather than more clarity and focus, and we're going to make the same mistake as we made with the Office of the OTS, the Savings and Loan Regulator, where we loosened the regulation so much that in 89, 90, 91, there was a problem across the savings and loan industry. On that cheery note, I'm going to turn to Mike Archbold. Mike may have mentioned to you that he has been the CEO of a number of organizations, but you also had the privilege of being the sitting CEO, I believe, when the Attorney General of New York attacked you. Perhaps you could take just a minute to talk a little bit about what you've observed and what has worked for you.
So, yeah, certainly. So I was the CEO at GNC when different attorneys general decided to come after GNC and the industry for a couple of different things. One of which was for whether a certain ingredient was actually even a so-called legitimate or legal agreement. And it actually brought to bear one of the places where there is a need for regulations, because it is done by the FDA. The vitamin supplement industry is regulated by the FDA. And they're the ones who determine what is the criteria for creating a legitimate ingredient. And there's different ways of doing that. But without getting into that, there were states that were then contesting whether something was a legitimate ingredient. This gets into one of the benefits of federal regulation, which is to create a consistent common set of standards so that we don't wind up with 50 different standards out there. Because as you can imagine, in any industry, complying with 50 different sets of standards would be virtually impossible. So I feel the pain of being in the finance world. So that was a successful pushback, if you will, on a state attorney general for overstepping the bounds, right? So they have lots of grounds on which they can, pursue interest, but it can't be whether an ingredient is legitimate. So it brought to bear the question about federal preemption being one of the benefits for regulation. The other place was actually from another state attorney general who did their own testing on products in our store and said that the products didn't actually contain what they contained, which was kind of interesting. Now, one of the benefits we had as GNC is we're vertically integrated. We actually source, manufacture, market, sell all of the products. So when they said that a given ingredient given product didn't contain the ingredient that he said it did, we found out that they were actually using the wrong tests. And again, it goes back to what's the industry standard, which is set by the FDA for the right test to determine what are the ingredients in there. To shortcut it, basically what it came out to was they were testing for DNA on products that had actually been synthesized for a specific ingredient within a product. And if you've actually gone through that process, in large part, the DNA, it's actually no longer present. So they weren't detecting the DNA after you've kind of gone through this whole synthesis. But it did bring up a positive, because we as industry leaders then said, you know what, okay, it's time that the industry embraced DNA. That's not the right place to do it, but there is a place to do that. And as a group, we then led the industry to embrace DNA barcoding in its proper place, really from the field when it's coming in, to actually test to make sure that you're getting the exact right plant that you are representing you're getting. So we actually led the industry to make the changes that were necessary, and we're able to do it where the industry aligned around it, created standards, actually wound up creating databases where we posted the ingredients and we agreed on testing for the most common allergens and posted them on a database where we gave it to the FDA. So everyone in the industry said, here, FDA, now you have it. So it was a place where the industry was able to resolve and keep pushing the boundaries of appropriate governance so that it wasn't necessary, in essence, for the FDA in that situation to come in to step in. So I think in both cases, they turned out well, and I think it really ties into the need for regulations. And I think while there are some who would say never and some who would say always, right? So the reality is, I think we all agree that there's places where it does belong and it does make sense. And typically those are areas like market failures. I think everyone agrees when we have, to avoid market failures or to address market failures, that's a place where regulation can help. Things like leveling the playing field, promoting innovation, promoting economic growth in that context is an appropriate place for regulation. The other place is about safety. So most people would agree that whether it's consumer safety, whether it's employer safety, whether it's investment safety, there's places where we would all generally agree. And then probably the last on the list, which is where it gets a little more difficult to get alignment, is things around social regulation, assuming fair distribution of benefits and things like that. So there's places where everyone agrees, and I think what we're trying to do is to make sure that we can come up with a consensus for us to agree to as CED as to where we want our legislators to focus to create the kind of smart regulations that we need.
Okay, thank you. Claudia, you're a nationally recognized expert in governance. You've had experience as a transactional lawyer. You've had dealings with the SEC. SEC has a new chairman, and there are tremendous demands on them. Things are mandated by Congress. Just thinking about regulation, how would you be thinking about the SEC today as a major force across the economy?
Well, thank you, Hollis. I mean, I think the SEC has a fairly robust process in place for making rules. You propose a rule, you seek public comment, and then you make changes to that in response to those comments, particularly constructive comments that point out unintended consequences or costs. But notwithstanding that robust process, on a number of occasions, rules have been struck down by the DC Circuit here. For instance, the proxy access rule. This was a rule that was authorized by Congress, allowing large long-term stockholders to put their candidates on management's proxy card. The DC Circuit struck down the rule as having an inadequate economic analysis, finding it to be arbitrary and capricious. Conflict minerals was another rule adopted by the SEC, this case mandated by Dodd-Frank. That rule was struck down on the grounds that it violated the First Amendment. And in talking about Dodd-Frank, you realize that a lot of the regulatory agenda of the SEC has been filled with mandatory rulemakings. And those mandatory rulemakings raise some questions, such as, are they consistent with the mandate of the SEC? And the mandate of the SEC is to facilitate capital formation, protect investors, and ensure fair and orderly markets. And I think there's a fair question on whether things like conflict minerals are consistent with those mandates. And then another issue has been that whereas the SEC traditionally worked by consensus, under the last several commissioners, rules have been adopted on a strictly partisan basis. So that has been a change. We have a new chairman now who's a deal lawyer by background, which I think is a great thing, and I think brings a fairly pragmatic approach to the commission. So out of the box, he announced some basic guiding principles that I think are helpful. The first was we need to look at rules retrospectively. We have a robust process on the front end, but we really don't look after the fact at, are they working? How much do they cost? What are the unintended consequences? Unfortunately, the SEC has not had a lot of bandwidth to deal with retrospective evaluation, but I think that's an important issue. The chairman has also pointed out that while an individual disclosure mandate may not be expensive, you should probably be looking at the overall the force of all these rules together, which creep along and become more and more significant. And another principle he enunciated early on is you need to look at costs of compliance, but real costs of compliance. And so what he pointed to here is the quarterly certifications that CEOs and CFOs need to provide when 10-Qs are filed. And it's not just the cost associated with their time. You have to look at the practical impact, which means you have sub-certifications from people throughout the organization who are filtering information up so those certifications can be signed. And you also have costs of third parties like accountants, outside lawyers. So the actual compliance cost may be much more significant than originally anticipated. One interesting thing I think the chairman has done is the SEC has a regulatory calendar. And the active calendar is typically a wish list, which is not, what's on it is not dealt with fully. And so this year we have an active calendar that's much shorter. So I think the chairman is trying to signal what he can move along. So I think that's helpful. He's also looking at deterrents to becoming a public company. Personally, I don't think the major deterrents are regulation, because you can tap the capital markets without becoming public. But to the extent you do wish to become public, there are rules that make that process more expensive. So under the current chairman, for instance, now all companies can file their registration statements confidentially. And this allows you to keep your sensitive information confidential until the time, if any, that you decide you're actually going to go on a roadshow and market your offering. And I think under the current chairman, we've also seen some helpful guidance. The CEO pay ratio, that's the mandated ratio of the CEO pay to that of the median employee. While it sounds like a simple concept, if you're a multinational or a complex business, that could be very expensive.
Or a retailer.
Okay, or a retailer, or lots of seasonal employees. It could be very expensive. So the SEC came out with some helpful guidance allowing flexibility in that calculation. I think that's very helpful for companies. On cybersecurity, the SEC recently came out with guidance. And here I think the guidance is you've got to take this seriously, because if we don't see improved disclosure, we may step into the breach and enter into some rulemakings. Similarly, on initial coin offerings, one of the latest and greatest, the commission has pretty forcefully, through the chairman, said things have to change. We think a lot of what's going on is illegal, and now we have a regulatory sweep. So I think what's happening currently is helpful, and I think it's pragmatic.
Thank you. Greg, if I could ask you, you've CEO, chairman, president, everything for Andeavor and Andeavor.
Yes.
And also for Andeavor Logistics. I hope I pronounced that right.
Correct.
And one of the things that you're in the oil and gas process, you do a number of things in that part of the industry. Oil and gas touch on so many areas.
Right.
Could you just talk a little bit about the regulations as you've seen them, and particularly how they might affect competition, and from your perspective, the new regulation?
Yeah, I'd be glad to, Hollis. I think that both yourself and Mike made a couple key points. You talked about execution, and Mike talked about the need for effective regulations. So in our industry, we have a tremendous amount of regulations. As a matter of fact, I would say that the biggest challenge or threat to our industry is not competition, but is the way it's regulated. It can have a tremendous impact on the health of the business. And to me, maybe one way to look at it is just to use a kind of a recent example, and it gets back into the execution of regulations. And this is more at a state level, where we were working on a particular project that both comes under the jurisdiction of both state and federal regulators, but predominantly the state regulators. And they actually had a process to permit a new facility, which is what we were trying to do in the state of Washington. And the process was actually designed to be quite effective and accomplish a number of different things. And we entered that process at the request of a port authority in the state of Washington to build a facility which would effectively allow us to take the shale oil being produced in the middle part of the country and get it to the West Coast, which had an environmental benefit because the quality of the oil relative to the oil that ourselves and other companies brought in from parts of the Middle East had a much lower carbon intensity. So by using that oil, it was the equivalent of actually taking cars off of the road from a CO2 standpoint. But anyway, the point of the example I want to give is about the execution of regulations. And in this particular case, we entered this process, which was defined as a 1-year process, and it took us 5 years to go through a 1-year process. And we funded everything that the state did along the way. At the end of the 5 years, we spent $40 million for the state to go through and take our environmental impact study and then have someone redo it all, and everything that we did along the way to be able to permit this facility that the Port authorities asked us to build originally, which had actually very good outcomes. To me, the real challenge here is when you take a step back and you look at the regulatory process, a few things stand out. One is just the execution, which you highlighted in the financial world. The second thing is that there's an absolute lack of accountability. So the overall execution of the process, which can lead to effective regulations, I mean, I think that is a good outcome, but the execution of it and no accountability it destroys competition. In this particular case, so we weren't successful with what we tried to do, but it took us 5 years to get there. It cost us $40 million. And along the way, there was no transparency, and there was actually no one in the numerous agencies within the state government that really had any say in what was going on. So it just kind of floundered out there, and you have no control over what you're doing. So I think the key takeaways for me is that to have effective regulations, it's not just the development of the regulation, but it's also how it's executed and and who's accountable to make sure it does the right things, because the value of the regulations is for society.
Absolutely.
It has an impact on society, and you can have effective regulations that have a very positive impact on society, but there has to be accountability along the way to do that. And then I think the final point that I would make is you can also develop a regulation which today sounds very good, but in 2 or 3 years things change, and the difficulty of changing a regulation makes it almost impossible when almost everyone would admit that there are unintended consequences and that there's a more effective way to get to a place that you need to be. So I think it has a tremendous impact on competition.
Well, that's a great, because I was going to ask Pat about unintended consequences, but you touched on something else. I hope Joe Caspiutes won't mind my mentioning, but he had done and looked at some measurements, some thoughts about measuring the impact of regulation against the size of your economy and being able to think about, is the cost of regulation, I'm butchering, I'm sure, a very thoughtful paper, but it is something that one of the things that I think we would all like to see is that there is some measurement, some accountability of the effectiveness. I mean, for Pat, you've been CFO of a number of major global institutions, Office Depot to Restoration Hardware. These types of issues have to have touched your office probably on a daily basis. You're now doing advisory work with Templeton Company. It's got to be some of the M&A and the advisory work that you do. What are the unintended consequences that you're seeing? How is this impacting?
Well, actually, as I was listening to Claudia, I was thinking, my goodness, it sounds like there's positive things happening. Maybe I'd want to go back and be a public company CFO all over again. Some encouraging thoughts there. It's interesting. So being in a CFO chair of a global company, one of the things that we often had to deal with is issues that were outside of the domestic environments. And so trying to change things in Europe, for example, with labor unions and so forth, you often thought, oh my goodness, what we deal with in the US ain't so bad after all. But now, as I spend a lot of time in the small to medium-sized business environment, you see how the impact of regulations on those SMB businesses have been profound and actually overwhelming to a number of those businesses. So if you think about it, I was sitting in the chair when Sarbanes-Oxley was launched. And, I think for all intents and purposes, certainly that was one of those, gosh, that was a great regulation, it was intended for good. But I think if all the research that's been done, I would say that I don't think anybody's come back and said, my goodness, that's really changed overall governance or the way that corporations really executed their responsibilities. But moreover, it's had some of those unintended consequences. So for example, I think back in 2003, there actually was a peak of the number of public listed companies here in the US of around 8,000 plus. Today, that number is around 4,000. So that has been a precipitous decline in the number of overall public companies, listed companies. And in addition to that, if you look at the market cap of those companies, in 2003, it was 1.8 billion. Today, it's around $8 billion. So not only is the access to capital been restricted precipitously to those S&P market environment companies, but also the size even of those that are going out there and IPOing is just far different. The good news is, the private equity and the VC market certainly have stepped up. So capital's been available to those S&B businesses. It's just different. And then if you look at those of you who've been around public companies, maybe been on boards or hovering around the board suite, I would tell you that when I first started hanging around the boards back in too many years than I care to count, in the early 90s, it was a far different conversation. There was a much more of a strategic conversation ongoing. And although I think most public company boards want to be there all the time, I think what you find is public company boards are spending a lot of time talking about compliance and talking about things that are risky. So I think another unintended consequence of Sarbox has been that overlay, just compression in terms of the way the public company boards think. And then if you switch over, I read a study that Egon Zehnder had put forth some research on the quality and the effectiveness of public company versus private equity boards. And their takeaway was, and this was a survey of a number of folks that sit on both types of boards, is that private equity boards are indeed more effective. And I think that goes back to, what's the reason for their being? And their being is to help drive strategy as opposed to being risk averse and to think about the overall issues as it relates to governance and so forth. So back to the unintended consequences, I think there certainly are plenty of opportunities. I think each one of us has touched on unintended consequences. And I'm so pleased to be a part of CED where we're thinking about what are the opportunities for being able to promote policies that might change the way that we think about regulations. And specifically, I think the pre-implementation reviews that need to be done and then the post-implementation reviews are so critical. And that's where I think that we can drive a huge difference if we can just get that piece addressed.
Thank you. We'd like to turn to Q&A if we could and give you a chance to ask questions. The panel has agreed that all the tough questions go to them. I would make one quick anecdote. We talk about business-related unintended consequences. My wife, Pat, heads up a small group that feeds the needy in the town of Portchester near our home. They give out about 45,000 meals a year. Someone approached them recently and asked them if they could take as workers some people who had come out of the penal, that were felons and needed their first job. And it sounded like a great fit between the work that she does and their need. But then they plopped on her table, and she's got only 4 or 5 people that work there, literally a very thick manual of compliance that they were going to have to sign off and attest to. And there she's sitting, wanting to do it. So even in a very benign social environment, when you put regulations that are well-intended, but she's usually then saying, I don't have time, I don't have lawyers, we can't do it. All right, on that cheery note, yes, identify yourself, please.
Sorry, Chris Myers with the Mercatus Center at George Mason University. We do a lot of research at Mercatus Center on regulation, specifically looking at the cost of regulatory accumulation over time, and also estimates that kind of work at each individual state level, not only the federal level, but each state code. But we also do research looking at the solution side, and we've done some work looking at what British Columbia did in Canada. Normally we think of Canada as our big government brethren to the north, but actually on a lot of these economic issues, they arguably outperform us in developing regulations and quality regulations. So they use a regulatory budget, for example, in Canada. Is there any other example of, from a solution-oriented side, another nation that has approached this problem of regulatory accountability from an effective way that you've seen?
All right. I don't think there was a question in there, was there?
Yeah, where else?
Where else?
You said.
Any other countries that have done kind of quality implementation of regulatory reform?
Okay. Mike?
So I would say that, one, that'd be a great example for us to use, because as we're trying to put together a book on this, some have pointed to the UK for some of the things that they have done. But I think that the concept of a regulatory budget is certainly leading the pack. So that is a construct that I think is very interesting. It's one of the things that we've been seeing if we can gain alignment around from our membership to drive that. I think it'll be tougher for us to get that kind of construct through right now, but I think we have to know where we're going, right? So we're looking at a number of potential recommendations, whether it be a regulatory budget, increased cost-benefit analysis capability within OIRA, the ability to provide additional analysis, cost-benefit analysis within Congress, so they could do pre-reviews, some ex-ante reviews of what the impact is. Kind of gets towards a regulatory budget, if you will, which is, I know what it's going to cost before we actually do it, right? So there are a whole number of things that we're looking at, and I think that a regulatory budget is certainly leading edge, and I'm not aware of too many others who have gotten there. Joe, do you know others who have gotten there?
There is a frequent application around the world.
Do we have a microphone for Joe?
There's an increasingly frequent application around the world.
Could we turn on the microphone for Joe?
There it is.
Okay. There's an increasingly frequent application around the world of ex post analysis. That's one of the most important
Yep.
things. UK is distinguished in some analyses with respect to the application of principles, as opposed to case-by-case, scenario-by-scenario rules, with the proviso that, of course, there is a criticism that in some instances the principles become banalities and don't actually bite. That's a question that would have to be resolved.
Yeah, great, thanks.
Yes.
Get your mic.
Hello, my name is Michelle DeGraff, and I'm from the National Parking Association, and my question is around labor regulation. Just wanted to know the panel's reflections on the last year and everything that's happened, and what you think will happen in the next couple months as the administration continues to reflect on what happened and make a new ruling, and how businesses can also come together to influence what happens in the future.
We have a volunteer for that?
So I guess I would offer some comments. I don't know about what the administration's done from a labor regulation standpoint to specifically address your question, but I think at a state level, in some cases, what we experience, because in our business, in the energy business, I mean, we have a tremendous focus on both the safety of people and the safety of the processes that we operate. And so what's very important to us is, and I believe this is a case where we have a very effective regulatory environment around workplace safety, around process safety, and even on the types of products that we make and how we can lessen the environmental impact. And that has a big impact on how people work. So the different, for example, different states in that have an approach that will not necessarily allow you to, they'll regulate to the point that they don't necessarily allow you to use the best people to do the work on skills in that, whether for whatever reason they choose to do. And that can be quite detrimental. So what we see, especially on the West Coast, where we have a significant market presence, is that the state regulations are kind of telling us who we should hire. And that can be a contradiction to our basic principles of worker safety and process safety, and that's a real difficult balance. But that doesn't probably answer your specific question about this administration. That's the biggest issue that I see from a labor standpoint.
Anyone else, or should we? We had a, yes, please.
Yeah, comments on the.
Could we have your name?
Michael Lachansky, I'm a grad student at Princeton University. I was wondering if you had any comments on some of the administration's new efforts to set up analytics offices to kind of create some more information flows between offices within the departments and agencies. So right now, FCC has a proposal for an Office of Economics and Analytics, things in that direction. Thanks.
Yay for analysis. So anything that's going to promote the interaction of and sharing of analytics between the different branches, the different departments is certainly a positive. The inclusion of things like economic metrics and understanding the impacts of those things is making a meaningful step towards understanding at least the impact of it, and would get to the post-review at this point, at least of some of the regulations that are out there. Hopefully, if we're very good at this, we'll actually get to where we're actually doing reviews in advance and understanding the impact.
And if I could add, I think I think Hollis, you even mentioned earlier the overlap of all these different agencies that tend to, one piles on, the other piles on the other, and then you've alluded to the states as well. That's what I hear a lot from the SMB side of the world, is that they just are, they're down at the lowest bottom end of the totem pole. So everything, kind of the avalanche comes on down to them with little ability to be able to affect. And then when the regulations are passed, there oftentimes you need regulations upon regulations to give clear out the ambiguity and to provide clarity. So instead, you've got these companies that are trying to respond like that to regulations that are imposed because they're short-lived. And certainly some of that analytical pieces, I think, would help to clear through some of that.
Sorry.
Yeah, I'm done.
Just to build on to give some scope to the analytical expertise that exists now, most of the review of cost-benefit analysis is done in this very small group called OIRA or OIRA, which exists in the Office of Management and Budget. There are 50 individuals in that office reviewing the impact of regulations generated by 300,000 regulators. They don't stand a chance. So one of the things that we're talking about is increasing the resources there, as well as increasing the resources in the individual departments.
One of the big differences, again, someone had asked earlier about the global regulator. The U.S. has fallen a little bit behind in terms of the extent to which it wants to treat its regulators as significant professionals. The Monetary Authority of Singapore pays full market wages to many of its staff, and they're able to attract some of the best and the brightest, but very importantly, they have retention. One of the things that has been so painful to see is what I call the repeated march on Moscow in winter, where somebody has forgotten that Hannibal tried it and that other folks tried it. And just keep repeating it. And as we lose regulators who have business cycle or experience because they can't send their kids to college, we're losing a tremendous amount of value. So one of the things we have to think about is, do we want to, in fact, pay them at a better scale, train them at a better scale, and in a sense that will be a real benefit in the long run. But right now, there is a visible gap there. Pat, would you just take a minute to expand a little bit on the issue of how the differences for big companies versus small companies? I think that's a really important topic in terms of whether the big companies, in fact, are able to maybe manage new regulations or regulatory relationships. And certainly Claudia or Greg or Mike, if you want to talk about that as well.
Well, I think it comes down to just scale. When you ask somebody to keep track of, the number of employees or the number of this or the number of that, the ability even to pay the compensation even for a small publicly traded company, the resources are fewer and farther between. So when you layer that in on top of just a very lean staff to begin with, as opposed to although I know where Steve is, but I would never have told him before that I had plenty of staff. So, but I had more staff to be able to access back in the day of my public company, where gosh, I had hundreds of people, within the finance organization. So you just told them to lay off over here, and they, pulled it up over here. but that doesn't occur as readily, and they don't have the analytical depth. So you're lucky in a small company that they have somebody that truly wears a hat that's truly a CFO type of person as opposed to a controller slash, bookkeeper. And mind you, the U.S. is still driven 50% plus of GDP is small to medium-sized businesses. So it's still a huge driver of this economy. Joe, did I get that right? Is that close enough? Okay.
Yeah, I think, SEC has done some things in terms of scale disclosure based on the size of the company. The Jobs Act basically created an on-ramp for companies to go public, and they need not provide as much financial data, et cetera. I think that's another thing that's somewhat helpful in encouraging companies to go. There's some incremental savings there.
Plus, I think that the larger company has the capability to manage the regulations, to say they can bring in the people, and it's not just keeping track of the regulations, it's managing the regulations to position themselves so they're maybe not as negatively impacted as someone else could be.
Yeah, sure.
We have unfortunately run out of time. From our perspective, there's lots we'd like to talk about. So Greg, Pat, Claudia, Mike, thanks so much for doing this. Appreciate it.